Okay, let's raise the big question then tonight. Should the President, Pranab Mukherjee, reject the ordinance that gives a reprieve to the convicted politicians? It's a CNN-IBN campaign that we've been carrying on for the last 24 hours. Prashant Bhushan, member of the Aam Aadmi Party, senior lawyer, joins us. Jayanti Natarajan, Union Minister in the government of Manmohan Singh, joins us of the Congress Party. Pinky Anand, member of the BJP and lawyer. BJ Panda, member of Parliament of the Biju Janata Dal, the one party that has consistently opposed this ordinance. And Aryama Sundaram, senior lawyer, also with us. Appreciate all of you joining us. Jayanti Natarajan, you're the one in the line of fire, so I must start with you. In the last 24 hours, it's becoming increasingly apparent that the UPA is slowly getting isolated on the ordinance. The only people backing you are parties like the RJD, the JMM, the Samajwadi Party, parties which have a number of tainted MPs and MLAs in their ranks. How do you respond? Will you reconsider your stand?
Rajdeep, first, let me put things in perspective.
Yes.
The government held an all-party meeting on the law, on the bill that was to be brought in, the amendment, to change what the Supreme Court had held on July the 10th.
Yes.
At the all-party meeting, all parties, Aam Aadmi Party is not in Parliament, all parties agreed, including the BJP, including the CPM.
No, ma'am, I must correct you. Two parties, CPI and Biju Janata Dal, and Jai Panda is on the program and he can back that, said that they were not in favor of any such law that would allow convicted MPs and MLAs.
Okay, that's okay, Rajdeep.
You stand corrected.
I'm talking about the BJ, okay, I stand corrected.
Okay.
But the all-party consensus, let me say,
was
that, except for the two parties that you mentioned,
that
the law should come. Right? Now, the only disagreement is people say that an ordinance should not, the other parties who are now opposing it, and you say we are isolated and we are not, is that an ordinance should not have been brought, that a bill should have, I don't know why they say an ordinance should not have been brought. I heard Mr. Raja say that why wait, Parliament session is round the corner, and every leader of the BJP that I heard only said, even Sushma Swaraj, that we are opposed to the ordinance, and that is why the President should not sign it and not the contents of the bill, to which we'll get later.
Ma'am, the ordinance is the critical point. The ordinance is the critical point.
Rajdeep, that's what I'm trying to tell you. I'm trying to tell you. It was brought in the Rajya Sabha. Nobody allowed Parliament to function. The opposition cannot have their cake and eat it. They can't say, we will not allow Parliament to function. We will make sure that the ordinance is adjourned.
Couldn't you have waited till the winter session of Parliament, ma'am? Couldn't you have waited till the winter session of Parliament? Because I'll tell you what, ma'am, I'll tell you what, the impression is growing that Lalu Prasad's case is coming up next week, which is why you brought it in a hurry.
Rajdeep, this is not the first ordinance, nor will it be the last ordinance that any government passes. Can you guarantee, Rajdeep, that the winter session of Parliament will run smoothly and that we'll be able to pass legislation? Even, the most important legislation...
What was the urgency of this legislation, ma'am? My simple question is, what was the urgency? What was the urgency?
My simple answer is, opposition did not allow the government to function.
Right.
Therefore, we brought in an ordinance. We will try to, and now it's in the standing committee. So what is the issue? It has been referred to the Standing Committee of Parliament.
You've given Lalu Prasad hope. You've given Lalu Prasad, who's facing a case next week,
I am not here. I'm sorry, I am not here. I am here to debate a larger issue and a very important bill which is in Parliament. I am here to talk about the rights of ordinary people and how they should elect their leaders in Parliament, whether they should stay there or not. I'm not going into individual cases. I will not be drawn into it. The fact of the matter is, almost all parties supported the bill. They are now opposing the ordinance for the very reasons that you are talking about. And the fact is that these parties did not allow Parliament to function and may not allow Parliament to function in winter as well.
Can I get Jai Panda to respond to that? Because here is a parliamentarian who has steadfastly said that that there should be no law which allows a convicted MP or MLA to get away. You heard what the minister had to say, Jai Panda. If Parliament doesn't function, the government has no option but to bring in an ordinance. How do you respond?
Rajdeep, I'll come to that in a short moment, but I want to make a point here.
Yes.
Our constitution guarantees that every citizen has to be treated equally.
Yes.
And the average citizen of India does not have the right to stay out of jail or to keep doing what he or she is doing if he or she is convicted. They do not have the right to run for election, to stand for election if they are convicted. So to provide a special privilege to those who are already elected, that they can continue just by appealing, even if they don't get a stay order, it is just flies against the basic rights that the Constitution guarantees. Number two,
Jay, I never interrupt you, but that provision is wrong, Jay. That what you're saying is wrong.
What is wrong?
Jay, because I'm sorry to interrupt. No, but what is wrong is it is only for 90 days, provided they get a stay. If they don't get a stay, the disqualification will come into force.
But an ordinary citizen doesn't have that right. An ordinary citizen, if I contest an election, I don't have that right.
I don't want to interrupt. Rajdeep, I don't want to interrupt Jay Panda. I'll let him finish, and I will state what I have to say.
Yes, Jay Panda, go ahead.
My point is that 90 days is something that an ordinary citizen does not get.
Yes.
And giving that privilege to a member of parliament or an MLA, it goes against the constitution. And many legal luminaries have said that you will require a constitutional amendment, not just a simple law. So something that requires a constitutional amendment, if you do it by diktat, which is by ordinance, it is not accepted. The Constitution provides, I think, by section 123 in very, very rare cases.
Yes.
Now that brings me to the other point which was being discussed earlier. Now this could not pass the parliament because although I think Jayanti Natarajan is right, there may have been some kind of a broad consensus excepting us and one other party at the all-party conference. By the time it came to parliament, the major opposition party and many others had changed their stand because of public pressure, because of activism. And as a result, this bill could not pass. And as to the final point, that because parliament does not function, you can pass bills by ordinance, I just do not agree with that in principle. If you want to follow that principle, please pass by ordinance the women's reservation bill. I will support you.
Jayanti Natarajan, you want a quick response before I widen the debate?
Yes, absolutely.
Yes, go ahead.
Yes, absolutely, Rajdeep. That the wider point is, even on substantive issues, Jay was talking about the Constitution. Under 145.3, Section 145.3 of the Constitution, a 5-judge bench of the Supreme Court has held exactly the opposite thing in Prabhakar versus Jayaraman, that if a lawmaker is convicted, they should be allowed to stay. If they obtain a stay, they should be allowed to continue in parliament and not be disqualified until the final decision is over.
Ma'am, I'm only going by the latest Supreme Court judgment. I'm going by the latest Supreme Court judgment.
Rajdeep, you are not even letting me complete a sentence. It's impossible for me to make a point.
Go ahead.
Even the provision of the Constitution says that on important constitutional matters, it should be a large bench, a 5-judge bench that should decide the law. A 3-judge bench in Navjot Singh Sidhu's case held the same thing, and now a 2-judge bench has held something different. Therefore, I say it's not unconstitutional, and the ordinance is totally within the 4 corners of the Constitution. Mr. Sibal says he has reframed the law to make it fall within the Constitution, and there's absolutely nothing unconstitutional about it.
I've got 2 lawyers on my panel. I'm going to go to them in a moment. In fact, 3, because Pinky Anand is both politician and lawyer now. But I just want to get Pinky Anand to get some clarity on the BJP. Yesterday, I had Nirmala Sitharaman on this very issue on the program, who said we oppose the ordinance because of the procedure. But she didn't make it clear to me whether she opposed the content. Do you oppose the content of this ordinance, or do you only oppose the manner in which the Congress has pushed it through? Let's get clarity from the BJP. The Congress may have played its card. Where does the BJP stand? Will you support convicted MPs being immediately disqualified? Yes or no?
Rajdeep, there's no yes or no to this.
There should be.
Let me answer it the way the question, there may be, but not for the time being. There are 2 things. One, the ordinance is being opposed on the ground of the timing, which is obvious to everybody and anybody concerned.
Yes.
Lalu's judgment is coming on 30th of September.
Yes.
The ordinance has been brought in only to protect him because he is ultimately thought to be possibly a possible ally to Congress, and therefore the timing.
Yes.
Now, it is high time that you stop bringing these ordinances out of a hat and throwing it at the people, whether it is the food security ordinance, whether it is the current disqualification, or the RTI ordinance, any of these.
Please answer my question. Is the BJP opposed to it or not in terms of the content?
the BJP is opposed to any content which is not discussed over the parliament as it should be under the constitution, and simply by Jayanti, for example, citing Prabhakaran or any of the other judgments, it doesn't make it any better. Ordinances are not justified on the ground that Supreme Court judgments may have varied. You can go to the Supreme Court and see clarification for that. Ordinances, the purpose
will the BJP support a legislation in parliament or not, ma'am? Will the BJP, let's assume it comes to parliament in the winter session, will you support it or oppose it?
The BJP will debate it. BJP is open to all suggestions which come from every quarter, including particularly what the people perceive and the people want. Okay. We want a clean political system for sure, and we have nothing to worry about in any case. Okay. So therefore, we are only talking about one aspect. You want to do something, don't keep... I like Jay Panda's. I like Jay Panda's statement. Bring in the women's reservation bill by the ordinance. Why don't we get an ordinance for that when the parliament doesn't function?
No, hold on. The good thing is Jay Panda is at least being clear. He's not calling for any debate like the BJP. But Prashant Bhushan, I presume the Aam Aadmi party is equally clear. I'm told you are now going to the Supreme Court challenging this ordinance. Do you really believe the Supreme Court will overturn an ordinance?
Yes, there are two very strong grounds for this ordinance to be declared to be unconstitutional. One is that there was no emergency for promulgating an ordinance. In fact, the same bill had been brought before the last session and has been referred to the standing committee. If there was an emergency, it could have been discussed and passed. In the previous session, the very fact that it has been referred to a standing committee shows that there was no emergency. In any case, there can't be an emergency in a bill of this kind. Secondly, the Supreme Court declared this, there was a previous law which was similar to this, which was declared to be unconstitutional by the court on the ground that you cannot make a distinction between being qualified to be elected and being a member of the House. Therefore, the same law which applies to disqualification for contesting an election will also apply to disqualification from being in the House. That's a constitutional prohibition where the Constitution says that the law must be the same for both. And therefore they said that insofar as the Representation of People's Act made a distinction between the two and said that an ordinary person who is convicted for a serious offence gets disqualified immediately, but a member of parliament does not get disqualified. He gets 3 months to appeal and so on, and thereafter if he gets it stayed from a higher court, then he does not get disqualified. They said that this is not permitted by the Constitution.
So you believe it's unconstitutional?
Now they are trying to do the same thing by means of this.
I take your point. I take your point. You believe that the ordinance effectively therefore is unconstitutional. Aryama Sundaram, do you believe it's unconstitutional, and to that extent, does the president have enough elbow room to reject an ordinance like this? Should a president be rejecting an ordinance like this in your view?
Look, there's one thing very clear, Rajdeep. There is no manner of doubt that the government has been very clear from day one that they do not like this law. They do not like the judgment of the Supreme Court. They are very, very clear. They moved for review. They do everything in their power. Strangely, they were supported by the other parties, and even today I hear my good friend Pinky Anand unwilling to say that the BJP will not support the ordinance if it was a bill or an act. But on the contrary, it seems very clear that they are getting political mileage now because of the huge public outcry against it by trying to, literally hunt with the fox and run with the hare. So I believe that to take this on this very thin issue, that we object to it because it's an ordinance, we'll discuss it when it becomes a bill. I do not agree with it all. All political parties, barring a few, have been very, very clear that they do not like this law. Now, let's understand about the constitutionality of it. The Supreme Court in its judgment said that Section 8(4) of the Representation of People's Act was unconstitutional. They said it was unconstitutional because Articles 102 and Article 191, both these articles had made it very clear that once the Parliament prescribes disqualification, a person cannot be in the House, cannot be elected. They said that since this had been made a disqualification, you cannot bring about an artificial divide through 8(4), allowing them to continue just because they are already voted. Now the important thing is that 8-4 was struck down because it was ultra vires the Constitution. In the absence of the Constitution itself being amended, in the absence of the Constitution itself being amended, I wonder how a fresh ordinance is going to cure the mischief.
So you're saying
Why?
the President should
because
reject
the fresh ordinances.
Should the President reject it?
According to me, well, the President could very well reject it and ask for a clarification on this aspect, because it is a question as to whether such an ordinance should come through, even if it is going to still run foul of the Constitution.
Okay.
However, to the best of my knowledge, if it goes back to the President, he has only two options: either to approve it when it goes back to him, or I'm not very clear on this, but to the best of my knowledge, he can refuse and refer it to the Supreme Court only if he feels that it violates the fundamental right.
He can. He can. There is a provision under the law.
The Supreme Court.
He can refer it. And
but that is the fundamental right.
That's right.
You're right, but that is the fundamental right. Not if it violates Article 102 or Article 191.
I get your point.
So therefore, I don't think he could. But he could definitely make a very, very clear statement by sending it back and saying, are you sure this ordinance has got over the mischief that the Supreme Court has pointed out, i.e., that the Section 4 or its equivalent runs foul of the Constitution. And without amending the Constitution, can you do it?
Can I just take that to Jai Panda? You know, Jai Panda, while I go for the politicians both yesterday and today who are in a sense supporting this ordinance, let's be clear. A majority of our netas appear to be supporting the ordinance, even if they may not say so because of public pressure. Because who knows which neta they say gets caught in some case or the other tomorrow. It's the fear of the law, and they say that if this ordinance is not allowed, what happens to their fundamental right for an appeal? How do you respond to that? That you are isolated within your own tribe, Jai. You are one of those lone voices speaking out.
I'm not one of those lone voices. My colleagues in my party and colleagues from other parties have also spoken out. We may today be a minority, but I think there is a public mood that is developing that many parties may not have tuned into. I think the situation will change. But the reality is this, that yes, indeed our judicial process is very slow, we know that, but that is faced by the average citizen as well, and we need to take steps to set up fast-track courts and to expedite the appeals process and so on and so forth. And as far as netas are concerned, there is a particular occupational hazard. You know, many times netas are booked for very minor offences such as dharnas and protest rallies and things like that. And one of the efforts was to distinguish serious charges versus trivial charges. I mean, if you are convicted of a traffic crime and you are to spend a day in jail, I don't think that should be grounds for disqualification or not to be allowed to run for election. I think some need is there to distinguish between serious crimes and non-serious crimes or trivial ones. But other than that, I don't think any...
In a sense, Jai, the court did that because they said convicted for more than 2 years. You know, Jayanti Natarajan, the fact is there is a public mood in this country. You know this better than anyone else. There is a feeling at the moment, terrible though it may sound, sab neta chor hai. That's probably not true, certainly not true. But when the public is angry, outraged at the criminalization and the corruption of our politics, surely you should have welcomed a step taken by the Supreme Court which sends out a strong message instead of worrying about the lalus of the world and those who may face conviction. You seem to have chosen expediency over public opinion.
That is your opinion, Rajdeep. It is not public opinion in the way.
Are you saying the public is not troubled by the image of politicians, ma'am? Are you saying the public is not troubled?
If you're going to give the answer as well, then
okay, please go ahead. Just remain silent. My apologies. Please go ahead.
No, my point is that when you say that, you know, this is a Supreme Court order, when I say that this is a Supreme Court order, we have to consider why. Now, is there a law? I totally agree with what Aryama said. There are very valid reasons. The court has stated those reasons. Article 102, disqualification. I mentioned 2 previous judgments of a larger bench. So we could go into technicalities until we are blue in the face.
Yes.
You're talking about the public mood. I want to ask a question. In this country, in the law of our land, the bottom line is presume a person is innocent until he or she is proven guilty. Now, My simple question to you, Rajdeep, is supposing a person after 90 days gets a stay from the court, or supposing a person after, and this is a matter which should weigh heavily on the minds of any right-thinking citizen, supposing a person after disqualification is now acquitted after the appeal, or after if a stay is given by the court, can you return that person's tenure? Are you going to force that person to
Panda, respond.
Now,
Good
Arima
point.
will agree with me. No, hang on. Arima will agree with me that that person cannot automatically come and sit in parliament. So that will be one more election. Therefore, you can't revive a dead tenure. Can you now give back justice to that person who might have been wrongly convicted? Can this not weigh upon our minds?
Prashant Bhushan, respond. Let Prashant is probably the best person to respond to this, since he's both a lawyer and an activist. Prashant, respond. What if someone is wrongfully convicted? He loses his seat. What if he gets a stay from the court?
You see, this
he gets a stay, then he continues. The Supreme Court has said so.
No, the Supreme Court said automatic disqualification. They gave a 90 days.
No, I'm very sorry. I'm very sorry. The Supreme Court said that if there is a stay of your conviction, then you can continue. It is very clearly said in the judgment that if there's a stay of your conviction, then in which case you continue.
Okay,
but if there is no stay of your conviction, merely admission of your appeal will not allow you to continue. Let's get that right.
Yeah, but the ordinance only talks of a stay. The ordinance only talks of a stay.
No, sorry. The ordinance talks of the appeal being admitted within. Sorry.
No.
The ordinance says that your appeal is admitted in 3 months.
Arima.
Mere admission of your appeal is sufficient.
Stay. No.
Then you get all rights, including voting rights.
The ordinance talks of a stay.
Okay, ordinance talks of a stay, but Prashant Bhushan, respond to the point that Jayanti has made. What if a person gets that stay in 90 days and within that time has already lost his membership? What happens to that poor neta?
So the question is, what are we weighing? On the one hand, we face the prospect of a person who has been convicted, found guilty and convicted by a court of law, not by a rival party, of a serious and heinous offence. That means, should he be allowed to stay in parliament even for 90 days? What is in greater public interest? That such a convicted person of a heinous offence should be allowed to stay in parliament even if he loses his seat, and thereafter, let us assume, she is saying that you can't presume him to be guilty, you have to presume him to be innocent until all his appeals are decided finally by the highest court and so on, which take for eternity. So therefore, what is in public interest? When we are talking about decriminalization of politics, the Election Commission had recommended that even a person against whom charges have been framed by a court for a serious offence should be disqualified. Far from accepting that recommendation, the Supreme Court, when the Supreme Court said that all right, if you are already convicted by a court, then you will be disqualified. Even this is not palatable to our netas, and the reason is that cutting across party lines, the BJP has 38% of its MPs who are facing criminal charges, out of which 19% are facing serious criminal charges. Congress has 21% facing criminal charges, out of which 12% are facing serious criminal charges. All these major political parties have a large percentage of their MPs who are really criminals. And they want these criminals to continue despite being convicted by a court of law. Therefore, all kinds of strategies are being thought of in order to allow them to continue even after they have been convicted by a court of law of a serious offence.
Let Pinky Anand respond to that. Pinky Anand respond to that. Prashant Bhushan says the Congress and the BJP both want to protect their MPs who have serious criminal charges. That is the bottom line. In your Gujarat government, I gave you I gave Nirmala Sitharaman the example of Babubhai Bokhadia, who has been convicted, continues in the Narendra Modi government. We have seen the Congress tie up with the Shibu Soren today back in Jharkhand. That is the nature of your politics. Therefore, you want this. This is opportunism of the worst kind, ma'am.
Rajdeep, there are just two things I want to say here. A, when Prashant talks about people who have charges against them, they do not have convictions against them. So these numbers, I don't know whether Prashant is assuming because they are charged, they have to be convicted, and therefore these grand sounding numbers which are being thrown across. Secondly, the question of public perception, I'm afraid we can't come in a parliamentary democracy to a time when the public perception is going to decide how the constitution of the country is going to be run. Thirdly, when you talk about people and the parliament, there are two different aspects. The parliament is basing itself on certain people who are already in seat. If you want to unseat them and to change the entire face of democracy in that fashion, I think we have another thought coming and we need to rethink this too. We have to go into a clear position of whether A, it is constitutional or not, B, whether you require to do something in such a post-hurry to evade all the ordinary processes and to come by way of an ordinance which itself is subject matter extreme exception aside from public morality.
Can I just make one point to Jai Panda? Why is it then that convicted netas win by such a large margin? Because a lot of convicted netas, when you ask them, say, you know, you people sitting in television studios talk of morality, I get elected again and again. Why should I be denied the right to contest an election? How do you respond when a neta talks like that, Jai Panda?
Rajdeep, I'll answer that in 30 seconds, but first I want to say about these arguments about people must be presumed innocent until all their appeals are exhausted. Look, why a law only for MPs and MLAs?
I didn't say that, Arima said that.
Yeah, okay.
Yes, I'm not saying you said that. I'm not saying you said that.
Yes.
My point is, why a law only for MPs and MLAs? Why not for bureaucrats who have been convicted, or policemen who have been convicted, or even common criminals, who have been convicted? Why shouldn't they also get 90 days while they appeal before the conviction takes effect?
In fact, Jai, you make a good point, because Jai, just to intervene, a senior civil servant has just sent me an SMS saying, if I get convicted in a case, I will be suspended for a long time with no hope of returning to my post. Why should politicians have benefits which civil servants don't? But go ahead.
So this is the constitutional guarantee that all citizens must be treated alike.
Yes.
Now the second point I wish to make.
Yes. Go ahead, Jai.
Well, the second point I would like to make is, if somebody is convicted even by a lower court, I'm sorry, I'm going to presume him or her to be guilty unless he or she gets a relief from a higher court. I'm no longer going to presume them to be innocent. Third point I wish to make is, I think you have a point that certain people who have criminal charges against them keep getting re-elected.
Yes.
I think this is a legacy of the past where a certain kind of a Robin Hood image helped, where the government was not capable of delivering services to the people, and somebody who portrays a Robin Hood image can get popularity while also crossing the law. I think we are changing as a democracy, and I don't think we are in a position to tolerate that anymore. And my experience has been in recent years that where the voters are given a choice between a clean alternative and a criminal alternative, and both are effective. If the clean alternative is effective in delivering services, I don't think criminals get re-elected. I can give you examples from so many instances.
Can I, Jayanti Natarajan, ask you, I think part of the problem, the worry with this is that there has never been a proper debate on this in the manner that it should have taken place. You don't bring an ordinance for Lokpal or an anti-corruption bill, but you bring an ordinance for self-preservation. That is the public perception. I know you say that I don't represent the public, I'll take your view, it's my personal opinion, but my feeling is this law has been brought for, ordinance has been brought for self-preservation. You won't bring ordinances on several other issues of urgent importance. Would you concede that, ma'am?
Except for the women's reservation bill, Rajdeep. If you're talking about the Lokpal, if you're talking about the corruption bill, all of us agree in principle that there should be no corruption, that there should be a Lokpal. But you know how contentious those clauses were. You know how it was argued. You know what efforts the government took to make sure that there was consensus. Why only in this case is there such urgency, ma'am?
Why only in this case is there urgency?
Said, in 2002, your own news clip, you said just a few minutes ago, your reporter said the BJP brought in an ordinance just like this. Now, if, as I said, July 10th, if the Supreme Court passes an order, in the monsoon session at the end of July, if we try to bring in a law, and if Parliament doesn't function, Isn't it logical that an ordinance should come? I don't understand.
There are so many other issues
about the bureaucrats.
I find parliamentarians should double the speed only when their salaries are at stake and now when their fellow netas are in trouble. That's my worry. Self-preservation.
I'm sorry, Rajdeep, that is such a cliche. You know, when you talk about politicians, I mean, talk about the salaries that politicians get.
Yes.
You know how much bureaucrats get? I don't at all feel sorry about it.
Ma'am, if a bureaucrat, I told you, ma'am, if a bureaucrat is suspended,
Rajdeep,
he will not get back his, his secretaryship.
You didn't let me complete that sentence. He will come back if he succeeds. Whereas an MP who's unseated cannot come back without an election.
Let him fight an election. What's wrong if he fights another election?
No, but then my point is, why should an MP fight another election when that MP was always innocent?
Okay.
Only in the case of a stay, only in the case that they're acquitted finally.
Ma'am, a 2 years conviction is usually for very serious crimes. A 2-year conviction is for serious crimes. Anyway,
the point is,
yes.
The point is that you cannot revive a dead term. You cannot give back to that person what they've lost.
Okay.
I don't see anything unconstitutional about the ordinance.
Okay.
I don't see anything strange about the timing because the order of the Supreme Court was passed on the 10th of July.
Okay.
Parliament was not functioning. It was introduced in Parliament. Nobody wanted to discuss it, and therefore the timing of the ordinance is only natural.
Okay.
I think it is in the standing committee.
I'm done completely out of time, but I want to give my friend Aryama Sundaram 30 seconds. Aryama, as you know, I don't represent public opinion.
I need exactly 30 seconds.
Maybe you do. Give me 30 seconds.
Rajdeep, the whole problem is I think everybody has gone on this debate without really understanding what the judgment of the Supreme Court was.
Yes.
The judgment of the Supreme Court was very clear.
Yes.
If you've been sentenced for 2 years, you will be disqualified unless you get a stay of your conviction and sentence. The judgment itself says so. In paragraph 31, it's very clear. I'm just going through the judgment, it's in front of me. This ordinance, if all it said was if you get a stay, then you're safe. You need not have had an ordinance because the Supreme Court judgment has already said this.
Right.
What this ordinance says is, if you file an appeal within 3 months and your appeal is admitted, then you can continue. In other words, the necessity of getting a stay is not there anymore. So let us understand, a person convicted for 2 years, if after that he merely files an appeal and it's admitted, he gets to continue. And the Supreme Court has very clearly said that cannot be done.
I get your point.
So what you're really trying to do is override the judgment.
Okay, well then the ball is clearly in President Pranab Mukherjee's court. We'll have to wait and see what the President does. For now, Pinky Anand, Jai Panda, Aryama Sundaram, Jayanti Natarajan and Prashant Bhushan, appreciate your joining us. And Jayanti, you can smile at the end of the program. It's always good to have a smile even though you're facing the heat from all sides. But thanks very much for joining us. Good to have you back.
We're used to it.
Good to have you back on India at 9. Editor's take, where do we stand? When Pranab Mukherjee was made president, the hope was revived that finally the country would have a Rashtrapati who would stand up to political pressure. Long-serving congressman, the UPA 2 ordinance on convicted legislators provides an opportunity to Mr. Mukherjee to show he is truly non-partisan. He must not become a rubber stamp president, but must exercise his constitutional obligation and raise questions over an ordinance that is being pushed through in an unseemly hurry. An ordinance is usually brought in as an emergency measure. The only emergency we see at the moment is that a potential UPA ally, Lalu Prasad, could be convicted next week. The Constitution places law above Neta. Will the country's first citizen please do the same?